Thank you so much for joining us for this free Thursday webinar. I'm Nikki Jovikic from Lookup Strata. I'm also the Managing Director of Tower Body Corporate in Queensland, and I'm your host. Living in owners corporations involves people sharing common property and spaces, which can naturally lead to differing views and the potential for disputes. So effectively addressing conflict is particularly important as owners corporation disputes frequently involve residents who must continue to live in proximity after the dispute is resolved. Fortunately, in Victoria, established processes are in place to assist with handling and resolving these kinds of disputes, typically using a multi-step approach. It's critical for lot owners, committee members and managers to understand the available avenues and processes. As Lookup Strata takes our transparency responsibilities seriously regarding partnerships, Horizon Strata Management and Tisha Liner FC Law are both sponsors of Lookup Strata, and both Joel and Philip regularly assist our Victorian audience with answers to their tricky strata questions. And as I mentioned at the beginning of the session, in addition to owning Lookup Strata, I own Tower Body Corporate. Before we begin, I'd like to mention that the information in the session, including the discussions arising from submitted questions and chat conversations, is not advice and should not be relied upon as advice. You should seek independent advice before acting on the information contained in the session. Very happy to welcome Joel Chamberlain, Director of Strata Operations at Horizon Strata Management Group. Joel has managed owners corporations and strata title properties in Victoria for over 15 years, working on a broad range of properties, including high-density buildings with multiple owners corporations, large land estates, and both commercial and industrial developments. Joel provides support for owners and committees in difficult scenarios, giving practical advice and guidance. Joel has assisted many owners corporations in Victoria to successfully remove insurance commissions from their annual renewal, saving thousands each year. We also welcome Philip Lehman again, Principal Lawyer at Tisha Liner FC Law. Philip specialises in owners corporation law, adverse possession and compulsory acquisition. He understands the unique nature of strata living and disputes and provides clients with a practical approach that's results driven. Philip assists owners corporations in governance and property law advice, such as interpreting plans of subdivision, leasing and licensing, adverse possession and dealing with managers and contracts. He acts for owners corporations in Victoria and in the ACT. So we're very happy to welcome Joel and Philip to today's session.
Perfect. Thanks, Nikki. Welcome, everyone. My name's Joel Chamberlain, as Nikki's just advised. I'm Director at Horizon Strata and Owners Corporation Manager now for just over 15 years in Victoria. Horizon's focus is on management of medium and larger size buildings. We have a range of these throughout Melbourne. As Nikki had discussed, my experience is reasonably broad and I've worked on smaller OCs, multiple OC properties over the years, managed large land estates and communities and worked with developers on new builds right through to completion. Today though, I'm excited to talk to you about an often daunting and quite confusing topic, I believe. That's the dispute resolution process and the intricacies that's around that. The idea today is to help clarify and maybe even refresh, but also give you some tools and tips to deal with disputes that you will indefinitely encounter in your journey as a manager or an owner or on a committee. We're going to break the presentation into several sections and both Philip and I will speak to various parts before we take some of your questions. We'll talk about the formal dispute resolution process and touch on some points about how to avoid or de-escalate disputes. Then we'll move on to what an OC needs to do if a dispute arises, and finally, what then happens if disputes are unresolved or where to go from there. Perfect. So, Philip, if you just want to touch on anything on your end before I...
Yeah, thanks, Joel, and welcome everyone. It's great to be presenting here with Joel today. So we'll run through, as Joel said, I'll talk a bit about some of the technical aspects derived from the Owners Corporations Act, and Joel will give us some really helpful tips and hints about how to try and get disputes resolved in the practical sense. Tisha Liner, we have a dedicated team here of 5 or 6 people that all they do is owners corporation work. So we're well equipped in helping lot owners, owners corporations and managers in dealing with owners corporation disputes, but also dealing with just general governance, interpretation of plan of subdivisions and everything else that an owners corporation needs from a legal perspective. Thanks, Joel.
Thanks, Philip. So I've just covered off a couple of things on myself, and thanks to Philip for his as well. So here's a quick overview of what we're going to talk about. But we'll jump right into it because I know you're all busy. So The first part we want to cover off is where do disputes and breaches sit in the legislation that we deal with. So the legal framework which we need to focus on when dealing with disputes is covered in several sections within the Owners Corporations Act 2006. And this includes Part 10, which you probably know well, or maybe you don't. And that sets out how you receive, address and should deal with the dispute in the first instance. Part 11 then focuses on your application to VCAT and is a step down the dispute resolution path, but it's necessary if the steps before it are, of course, unsuccessful. These sections can be a bit confusing, and I have seen several interpretations of the process, which is one of the reasons why hopefully today we can simplify that for you. We're setting aside the short stay disputes today just because that's an additional topic which does require much more time and to be more in depth. However, I would like to just point out there is a newly introduced power to make a rule which recently became available to owners corporations struggling with short stays. In your own time, you can check out Schedule 1 of the Act, and that's the power to make rules, specifically Clause 5.5. So, secondary legislation that supports Part 10 and 11, and that's the model rules for an owners corporation, and of course, any additional or consolidated rules that you might have registered on title. So under the model rules, we rely primarily on Clause 7, which sets out the process for dispute resolution. As always, my advice would be to default to the model rules as a starting point to ensure that you comply with your obligations under Section 140 of the Act, and that talks about rules having no effect if they're inconsistent with law, or in this case, they limit or avoid an obligation under the model rules. So in short, having an additional rule that overrides or avoids the process under the model rules is likely to be unenforceable, but you need to have that checked, of course. So that's those are the legal framework parts, and how do we then avoid disputes? If we want to avoid disputes or even cut these off before they become much larger than they need to, that's obviously our aim. We don't want to spend more time on dealing with disputes as they're quite distracting and they cause issues that we could be focusing on more practical or valuable things for an owners corporation. I'm sure that as a committee or a manager and even an owner, you've attempted to avoid disputes wherever possible. They happen too often, and a majority of the time these can be avoided or at the least de-escalated before they reach a formal process. In my experience, 80% of the time, disputes can be resolved with a few simple steps which avoid the need to initiate any action under Part 10 or 11. However, 20% of the time, the complaint or dispute is either very serious, it might be a repeat of prior behaviour, or it could require formal action to address the matter appropriately. In some cases, the complainant simply can't be reasoned with or is a nuisance altogether. I feel very sorry for you if you have one of these people in your owners corporation, as they can drain your resources, your time, your patience, and of course distract you from more important issues facing your owners corporation. There are a couple of simple steps to try before things do escalate, and these might sound simple and maybe a bit obvious, but you'd be surprised at how some people do approach a dispute. I would say that issuing a breach notice straight away is not great practice. But in saying that, you might operate in an environment where the committee has instructed you to issue breaches for simple rule violations, such as washing on balconies or parking in visitor parking. That's fine to do, of course, but wherever possible, try to avoid this direct approach and replace it with maybe a humanized interaction, such as a direct phone call or email. And I say this on the basis that you actually have the time to do that, because I understand some managers and committees are extremely busy. Alternatively, a letter can be sent to the alleged party notifying them there has been an observation of them in breach and that they need to cease that activity immediately. Failing that, you will initiate the formal process. The letter should include the rule that they've breached and what they can do to remedy that issue. This is often a softer version of a formal breach notice and should use generalized language like you've been observed doing activity A, or we advise you that activity B is not permitted at the building, but please ensure you refrain from doing this in the future, etc., etc. Most of the time, the alleged party is unaware of the breach or comes forward and apologises, as it is simply circumstantial, and we move on. If this doesn't work, then we need to consider if it warrants escalating the matter to Part 10 of the Act. Ideally, we want to limit breaches where possible. We want to avoid confrontation wherever we can, and most people, including myself, don't like a confrontation. You're heading down the path of issuing a formal breach under Part 10, then remember this can cause parties to become defensive or confrontational. After all, you're telling someone they've broken the rules and no one likes to be told off, even if they've done the wrong thing. The formal process under Part 10, it requires time and effort from not only the manager, but the committee, sometimes a separate grievance committee, and parties to the complaint. This will undoubtedly be costly as well for the OC, as given most managers will charge for their time when attending to breaches, meetings, and anything dispute related. I'd encourage you to attempt to resolve these issues wherever possible to avoid Part 10 and the dispute resolution process. Now, I might just hand that back to Philip to take you through the next part. Philip?
Great, thanks, Joel. So we're going to talk about Part 10 and the dispute resolution process set out under the Owners Corporations Act. One thing that's the parties really need to be mindful of is Section 152, which is the start of the section, deals with complaints between a lot owner or an occupier of a lot or a manager who is complaining about an alleged breach by a lot owner or an occupier of a lot or a manager of an obligation imposed on that person by this Act or the regulations or the rules of the Owners Corporation. Section 152 does not apply to breaches by owners corporations. So I just wanted to kind of start that as a starting proposition, because I think a lot of people mistake that Section 152 applies to everybody, including when a lot owner has a complaint about an owner's corporation, but that's not the case. And that's reinforced by a case that we'll talk about a bit later if we have time at VCAT. So in order to trigger this provision, the complaint needs to be formal and it needs to be in the approved form. An informal complaint or an email to the manager complaining about something in particular will not trigger the formal process set out in the Act. So it's really important that if someone's going to take, if all those good, helpful steps that Joel's provided have failed, then a lot owner or a manager wants to take it further, they need to do it in the approved form. And there's an obligation on the Owners Corporation to provide a complainant with the approved form if they need it. Now, complaints can't be about personal injury matters or about monies owing to an OC. The process is that the complaint needs to be completed in the approved form provided to the Owners Corporation, and the Owners Corporation must decide to do one of three things. They can either take action and follow the process set out in Part 10 in respect to the alleged breach. They can apply to VCAT for an order requiring the person to rectify the breach, and that might be appropriate in situations where the breach is having an adverse impact on the Owners Corporation, lot owners generally, or it's really significant or serious issue, or to take no action in respect to the alleged breach if they decide that, there's just really nothing in this complaint. The OC cannot go to VCAT before following the dispute resolution process under the rules, and the OC, if it's satisfied the matter has not been resolved through that process. So when we're talking about a breach or a complaint between a lot owner and a manager and another lot owner or manager, then it's really important that process is followed. Now, there's a dispute resolution process that Joel mentioned in the model rules, and we'll talk a little bit more about that in depth shortly. But it's really important that whole process is followed through Part 10 before you go, because VCAT particularly has, and the Parliament has a view that if there are disputes between lot owners, for example, they really would prefer the lot owners and the Owners Corporation to resolve that internally through the defined mechanism for dispute resolution before clogging up VCAT to kind of make it a determination if that's possible. VCAT really should be the last resort when all else has failed. It's important that if the Owners Corporation decides to go to VCAT in relation to an alleged breach, they need to have reasonable grounds that the person's actually committed the alleged breach. So it's not enough for the person to make a complaint and say, look, Bill at Lot 5 has breached the rules because they've done something. The OC really needs to investigate, undertake some preliminary assessment and work out, has there actually been a breach? Is there reasonable grounds that the person who's alleged to have committed the breach actually breached it? So a classic example is Bill has a dog. The dog relieves itself in common property and Bill doesn't pick up the mess. and there's a rule about, you know, keeping the common property clean and tidy. And you know, Jill comes along and makes a complaint about Bill and his dog. The question is, was it Bill and Bill's dog or not? Now, you need to have reasonable grounds to believe that it's Bill and Bill's dog. Might be that Bill's the only one who has a dog, and everyone sees him, you know, walking around with his dog, and he doesn't pick up after the dog. Or it might be that you know, everyone has a dog, and it's really unclear who is the culprit. So it's really important that the OC kind of takes reasonable steps to work out if there is an alleged breach or not. So if the OC takes no action, it must give written notice of the decision to the person who made the complaint and set out the reasons why they decided not to take any action. So it's not as simple as just simply writing to the complaint and saying, hey, we don't really, you know, we don't think you've got a valid complaint, see you later. You really need to go into depth and work out, well, what are the reasons of why the OC refuses to take action, and put it formally in writing, because those reasons, it's like when you go to VCAT and you get a decision, the OC needs to set out a reasonable basis in accordance with their obligations to act in good faith and honestly as to why they have chosen not to take further action. And it might be as simple as there's not enough evidence to justify that the person is being breached on reasonable grounds. It might be that they don't believe that it's actually a breach of the rules. And in order to make that assessment, the OC is entitled to go off and get expert evidence or opinion as to the complaint. So if the situation is, well, the OC is not sure it's an actual breach, they could go off and get legal advice about that. If there's a breach of some other aspect of a rule that requires a specialist expert to give an opinion, for example, you know, you might not be able to put load-bearing items on your floor, and someone's put a 500 kilo safe on their floor, and the person below is concerned that it's in breach of the rules. Now, presuming that the rule is enforceable, or that the OC is comfortable that it's enforceable, they might go, well, okay, well, we'll take further steps and work out, one, is that going to be an impact on the structural integrity of the building? And if it's not, that might be the reason why they don't take any action, if, for example, that safe's been put there. So it's important to remember that if the OC decides not to take action, it does not need to hold follow up any subsequent steps out in the rules, such as holding a grievance meeting. It can simply stop right there, but it needs to have a reasonable basis to do that. If the OC wants to take action, and it's arising from a complaint issued by a lot owner against another lot owner or a manager in accordance with 152, then a notice to rectify the breach needs to be formally provided, and it might be that, you know, informal steps are taken before that to try and avoid that, but then the person has 28 days to rectify the breach. If the breach is not rectified, then the OC has another decision. They can either give more time to comply. So, you know, the person might say, look, I've got an awning that breaches the model rules. I need another 30 days to get a contractor out there to remove it, for example. Or alternatively, they can give a final notice, which gives further time, or they can not proceed with any further action. They might say, look, we've given a notice to rectify the breach, but look, this is really a small issue. We don't think it warrants going further, you know, for the OC to incur further costs and further steps in this process. If a final notice is provided, it has to be in the approved form. These approved forms are available through Consumer Affairs, and the person has a further 28 days to rectify the breach. And the notice needs to state that if the breach is not rectified, the OC may apply to VCAT. Now, it's important that if the breach, you know, the breaches can be multiple breaches. So, for example, if you've got more than one breach, you can list all the breaches that you want to put in. And it's not a matter of car parking. So, a classic example is someone parks in a visitor car park and it's in breach of the rules. Now, if I issued a breach notice and I've got my car in the visitor spot, if I remove my car and then I park the car back into the visitor spot a week later, I haven't actually rectified the breach. I might have rectified the initial incident, but I haven't actually rectified the ongoing breach, which is parking in visitor car spaces. So it's really important that if you do receive a notice or a final notice, you don't get too cute about whether or not you've technically satisfied the breach by dealing with the actual incident rather than the actual issue. If a final notice is not complied with, then the Owners Corporation's got a final decision to make. Now they've had 3 decisions now decide to whether or not to go to VCAT. This is their final chance to go to VCAT or decide to take no action. And in any event, they've got to provide their decision in writing. So there's a common theme here. The OC effectively becomes like VCAT in this situation where they, assess the complaint, they decide whether they want to escalate it to VCAT, decide whether they want to escalate it by putting these formal notices or simply taking no action. But in any event, they really need to be careful about drafting the response, because what will happen is if the complainant is not happy with the response, they'll usually use that as part of the evidence that's to go to VCAT. It's important that complaints are and the nature of complaints and the number of complaints are reported at each AGM. So Section 159 of the Act requires it, and it sets out specifically what is to be included and not included in a report. And what's important is you can't identify the person who made the complaints or the lot owner or occupier alleged to have committed the breaches. So for example, it might be that you say, all right, there were 5 reports and the nature of the breaches were, one was in relation to the parking visitor spaces, one was in relation to leaving mess in common property. But I couldn't say that, put a report to say that Bill, Jane complained about Bill, and their dog or whatever. So it's really important that you don't identify personal information. Otherwise, the Owners Corporation or the manager will be in breach of the Act. If an Owners Corporation is aware of a breach, it doesn't need to follow the process in Part 10, particularly in Section 152. So under 153, they have the ability to take action or apply to VCAT or to take no action if they're aware of a breach, but they don't necessarily need to give the notice to comply or the notice to rectify and a final notice in order to go to VCAT. So if the Owners Corporation has not received a complaint from a lot owner, or they can just go off to VCAT if they want.
If the dispute is not resolved, then the OC must then notify those parties of their rights to take further action under Part 10 of the Act. And of course, that can flow into Part 11 as well. Notice should be given in writing, of course, and to both and by both email and mail, if possible. And that is to give notice to the person to whom the notice was given under subsection 1 and any person who made a complaint under subsection 152 in respect of that alleged breach. If you're breaching a resident, for example, it is also important to notify, or so you might be an occupant, sorry, to notify the lot owner and potentially their managing agent because it relates to their lot. And the last thing we need is for a lot owner or agent to be advised of a situation at the pointy end of a dispute when they could have assisted with resolving it in the early stages. I think that's a really good tip as well. If you are dealing with something or an alleged party that's in breach and that party is an occupier, it might be a tenant, for example, speak with their agent first up and potentially notify the owner as well, because they may not be aware of it and they may be able to then lean on that tenant to deal with that issue directly rather than you fighting it out with the tenant yourself. So agents are there to assist us. So it's always best to try and use them when you can. They also have a job to do, which is address things that their tenant does or doesn't do, for example.
Model Rule 7, and it sets out the requirements. So it's important that OCs, as Joel says, check the model rules, but also check their registered rules, because the registered rules might provide a dispute resolution process. But as we know, to the extent that registered rules don't have something covered that is covered by the model rules, then the model rules will also apply. So if you've got registered rules and they don't include a dispute resolution process, you fall back to the model rules and Rule 7. So it's important that you check both.
This is under the model rules. So the party making the complaint must, of course, prepare written statement in the approved form. There's a grievance committee. It, of course, must be notified of that dispute. If there's no grievance committee, then the OC must also be notified. So that would be it's quite a lengthy process, but let's hope you have a grievance committee in place and they can address those things there. Then, of course, the parties to the dispute must meet to discuss the dispute with the grievance committee or the OC, and that's really your opportunity to come together and try and resolve the issue as best you can. Sometimes that doesn't happen, but it gives everyone that ability to have their say, and it's quite, I guess, it can be quite a longer meeting if necessary. People will come through and try and air their grievance or their issue with the other party, or for whatever reason they're there. So it's important to listen and give everyone the equal opportunity or an opportunity to provide their statement about what their issue is and how they want it resolved, and then for other parties to listen, and then for the grievance committee to try and reason and mediate between the parties to come to an understanding or a resolution where parties can exit that grievance meeting feeling satisfied that the dispute has been resolved as best as it can be. In some cases, there may be compromises that are needed, but hopefully get to a point where things are resolved for everyone involved. That meeting, of course, must occur within 28 days of the notice coming to everyone's attention. And then the meeting may be in person or by phone or video conferencing. A lot of the time I've found that these days, and after the pandemic, that people are more suited to meeting via video conferencing, such as we are doing here, because, as I said earlier, confrontation is something that people don't like, and they feel sometimes intimidated by others in a meeting face to face. So wherever possible, if you can try and facilitate a video conference, that is usually more preferred, but often some people are happy to have it face to face, of course. So choosing the right location for that is also something to keep in mind. 7, so a person may appoint a person to act or appear on their behalf. This does happen from time to time, a bit like a proxy. But that people are entitled to do so. And finally, the grievance committee may obtain expert evidence to assist with the resolution of that dispute as well. So as Philip touched on, it's important to ensure that you do have enough evidence to get to the point where you are at that grievance meeting. The grievance committee may then obtain additional expert evidence or a witness or a consultant to investigate that complaint to ensure that there's valid grounds to hold that meeting and deal with that dispute. So really important that the OC does its due diligence in that respect. And of course, if the dispute is not resolved, then the OC must notify the parties of their rights to take further action under Part 10, which is what we talked about before, notice in writing, and also email, mail. Both of those is preferred. Okay, practical advice. So we've covered most of this in the presentation already, but just to recap, the OC should be encouraged to provide open and transparent communication to lot owners. This is really helpful, helps people understand what's going on, and they can then make an informed decision, of course. Managers should also act early and try to open a dialogue early between parties in that dispute. As I said, phone call, email, sometimes a letter, helping, using the agent to help you with dealing with the tenant if it's around a tenant's behaviour or an issue that they've breached. And of course, if that doesn't work, then use the formal process under Part 10 if those informal steps have failed. Sometimes it's necessary to hold a dispute meeting so that parties can come together with an independent party to air their grievances and or have their day in court, as it were. So pretty straightforward stuff. If the manager is not a party to the dispute, then having the manager or a lawyer independently chair that dispute meeting is the best way to do it, so the parties feel that they're getting a fair go. Having an independent person such as the manager or a lawyer is the best way to deal with that. And make sure everyone has that reasonable opportunity to present their side of the story. So opening statement, maybe a responding statement, and then trying to work through the best way to achieve a satisfactory outcome for everyone there. Make sure reasons for not taking action are reasonable and properly thought through, and these should be communicated clearly to parties in writing as soon as possible. And then, of course, consult with a lawyer if you're not sure. Now, this is really important because as managers and owners and committee members, we do not practice or study law. Some of you may, but I think most of us don't. So our ability to interpret legislation or act appropriately in these matters is often questionable. So when we need to, wherever possible, engage with a solicitor to ensure we're on the right path. Even as simple as seeking written advice or a 30-minute teleconference with a solicitor to ask several questions puts you in a far better position legally than simply trying to do it yourself. And in the event that the matter escalates beyond the basic dispute resolution process, that solicitor who you initially engaged will most likely act for the OC or a party at VCAT. I think that's really it. That's all we've got time for today. So thank you everyone for your time. Hopefully that's a bit helpful and you've picked up a few tips or clarified the path through disputes. So Nikki, I think we've got some questions.
Before you do, Nikki, I noticed there was a couple of comments about managers and disputes with managers. So maybe I'll touch on that briefly. So I think there needs to be a distinction between a dispute with a manager that is by a lot owner and a dispute which is rightly by the owner's corporation. So there's a real distinction. The owner's corporation engages a manager as their agent to carry out the owner's corporation management tasks in accordance with the Act and mainly in accordance with their contract of appointment. So all managers require a contract of appointment. Now, if a manager fails to carry out their duties in accordance with the contract of appointment, that's a potential breach of contract, but that's a claim that can only be made by the owner's corporation against the manager. A lot owner doesn't have standing to make a complaint or to prosecute a manager for a breach of contract effectively. Now, they might have the ability to make a complaint against the manager in circumstances where the manager's in breach of a statutory duty, but it's a really fine line as to whether that claim can be pursued by the lot owner or by the owner's corporation itself. And the other thing that I come up really quite often, particularly with unrepresented people who go to VCAT, that is lot owners will generally always think the manager is the person responsible for decisions of the owner's corporation. Now, whilst in some cases managers will have the authority to bind the owner's corporation and make decisions, even when they do have that authority, almost in probably 95% of cases, they've only taken a step or undertaken whatever they've done on behalf as agent for the owner's corporation, and normally on the instructions of either the owner's corporation, drawn out from what's been resolved at the AGM, or alternatively from the committee who have made decisions on behalf of the owner's corporation. So it's really important that lot owners get rid of this idea that the manager is always the one in wrong. Now, it might be on occasion that the manager is the one who hasn't completed the instructions of the OC or the committee, but in most cases, they've just followed what they've been told to do. And it's the committee that's responsible for those decisions. But it's not the committee that are going to be pursued either. It's the lot owner needs to pursue the claim against the owner's corporation itself as the responsible party who's technically made the decision. Now, there are cases where there might be a breach of statutory duties by a committee if they haven't acted in accordance with that, but they're pretty high bars. And normally the decisions are decisions that a lot owner's not happy about the owner's corporation making. So I just wanted to clear up that if there's a dispute with a manager, it's for the owner's corporation to pursue, unless, of course, it's something that the manager's doing outside the scope of their power or obligations under the Owners Corporation Act. So, for example, if the manager's stealing funds, again, that's an owner's corporation claim, not a lot owner's claim.
Okay, thanks so much, Philip, for that clarification and for picking that up out of the chat. And thank you to both of you for the presentation that was just being put forward. I think that was great, really great information in there. We do have quite a few questions. We've just been asked about clarification between the term Owners Corporation and Owners Corporation Committee.
Yeah, well, Owners Corporation is the legal entity, and they make decisions either through general meetings or AGMs with the lot owners making the decisions, or through the committee if they've got delegated power, or if they haven't been received some delegated power, then through the general powers that they have been delegated under the Act to make ordinary resolutions. So I think some people confuse, whilst the committee is a group of people elected, they're making decisions on behalf of the owners' corporation. So the decision's always the owners' corporation's decision, not the committee's decision.
Okay, thank you for that. And we were also asked, what if there is no active owners corporation or strata manager in a scheme?
Well, I think the answer is to try and get one. I mean, managers are very good at running owners corporations. That's what they do every day of the week. And if you don't have a managed scheme and there are disputes that are arising or people aren't paying their fees or there's something else that occurs that's causing dispute, then my first advice to unrepresented people is to go out and get a manager, because a lot of the time, as Joel's put, managers can be that kind of circuit breaker that can be the voice of reason without going legal. And they can also lay down the law and say, look, I've done this 50 times and the Act says you can't do this or you can do this. And they can really, help promote and deal with issues at a level. I'm not sure if you got anything to add, Joel?
No, I completely agree. I think is exactly what you said. Having a manager in place just gives you a little bit more guidance and assistance in those tricky times. And again, the 80-20 rule, 80% of the time, you may not need a manager because daily life goes along, but then the 20% of the time that you are facing down the barrel of some of those things you just listed, Philip, you do need a manager. So it's better to have one in place, and they'll deal with those sorts of things where they can for you. So yeah, I agree with you.
Okay, great, thank you. Can a committee authorise the manager to issue a breach notice for an evident breach of the rules in the absence of a complaint form?
Yeah, they can. So if a breach comes to the notice to the owners corporation absent a complaint, then yes, they can issue breach notices. They can issue a breach notice, a final notice, or they can go off to VCAT. I think it's always best that, as Joel said, send a letter first, an informal kind of friendly but firm request to comply. And, rather than kind of running off to a lawyer straight away or running off to notices of breaches, if you can avoid it, because ultimately everyone's got to live together. When that dispute's over, everyone's still living next to each other. It doesn't pay to, and personality conflicts are probably the biggest cause of disputes, where someone feels aggrieved because someone parked in someone's car spot 10 years ago and all of a sudden they hold a grudge for the next 10 years. But at the end of the day, you live together. You got to try and live as harmoniously as possible. But yeah, the owners corporation can definitely take action independently of a complaint.
Okay, we've also been asked, what is the appropriate course of action where if complainant refuses to participate in a grievance meeting? We understand the OC cannot investigate or act on harassment claims, as this falls under civil or police jurisdiction. Is that correct?
Initially, an example of this has happened with one of our owners corporations in the past few months, 6 months or so, but earlier this year, where we had a complaint made against various parties by an individual, and the committee said, well, look, we believe that we at least want to go through the grievance meeting process, and they did that. They have attempted to call, just earlier this week, I was speaking to the individual, or one of the committee members who was dealing with it, and they said, we've attempted to call 3 grievance meetings to get these parties to the meeting to try and discuss this. And on all 3 occasions, those people have failed to attend, or the party making the complaint hasn't been able to attend or hasn't wanted to attend, for example. They believe that they've been wronged, et cetera, et cetera. So she was then asking my advice about, what do we do next? And I said, well, look, you've attempted to follow the process through the Act and the rules. You've tried to call a grievance meeting more than I probably would have. 3 times is quite considerate. If you haven't done that, then I think at that point you can go back to that person and say, hey, look, well, they complained and say, hey, look, we've attempted to, you've not made the effort, we've complied with our obligations under the Act. At this point, you're free to do what you want in terms of those mechanisms available to you within the Act. We're not going to take any further action. If you bring the complaint to us, we try and facilitate the grievance meeting a few times, and you don't turn up, we can't do much more than that. So you're now free to do whatever you want. We're going to close this matter. So I think It's really up to you at your discretion, but I think at least 3 times to call a meeting without any success is enough, Philip. And you might have something to add about the next steps through the legal process.
Yeah, look, the only thing I'd probably add to that is if it's a complainant that is refusing to attend a meeting, I would, or if it's the other person, the persons who are alleged to have breached it, I would contact them and I'd say, look, we need to hold a meeting within 28 days. Please give us 2 or 3 suitable dates and times during business hours that you can attend a meeting either in person, by phone, or via Zoom or Teams or whatever, video conferencing. Give that to us within the next 7 days. If you don't, if you're the complainant, well, then we're probably just going to decide not to take any action. If it's the alleged breacher that refuses to go, I would, in the absence of them confirming a time that suits, I would just set a time. I'd have the meeting. I'd listen to what the complainant had said, and then the OC can then make a decision based on the information they've got in hand as to whether or not they take further action, take no further action, or go off to VCAT.
What time frame do the OC have to issue the final breach after the initial breach is sent, post the 28 days?
I don't think there's any time frame stipulated by the Act. With that said, I think it needs to be within a reasonable time frame. You know, I've had matters where someone said to me, "Oh yeah, we issued the breach notice, 9 months ago, and should we issue a final breach notice now?" I think, if it's if you've waited more than 3 months, I think things get a bit stale. I think you might not do a final notice, day after the initial notice expires, but I wouldn't be waiting months and months and months. I think you need to kind of keep it in a relatively short time frame.
And can they be emailed, or do they have to go by post?
No, they can be emailed. Email service is perfectly acceptable, providing that there's an address of service that's being provided. Same with fee notices. Fee notices can be emailed. That's perfectly acceptable service under the Act.
Thank you. Can something be said about the limits on delegations from the OC to the Owners Corporation Committee under Section 11 or Section 101?
Well, I mean, an owners corporation, when the committee is elected, they're entitled to restrict what a committee's delegated power is. So, back, pre the 2021 amendments, it was very common for a lot of managers to have a requirement that you couldn't terminate a manager or appoint a manager without it being a decision of a general meeting. That was probably one of the only real restrictions and delegations I would see. Then that effectively became prohibited, and I think rightly so, managers realised it probably wasn't the right thing to do either. But no, providing the general meeting or the AGM sets out what are the limitations, then you can impose limitations. Quite often I see limitations which are kind of, the OC committee can authorise repairs and maintenance up to a particular level, say $5,000 but if it's more than that, they've got to go back to a general meeting, even though the Act says that they can authorise it up to twice annual fees. The annual fees might be 100,000, but they go, you know what, if it's more than 20,000, come back to us. And that usually is for smaller OCs that I see. Joel, do you see anything kind of different?
That's right. I mean, ultimately, you appoint that committee to act on the owners corporation's behalf, and you trust them to make the right decisions. And the Act has circuit breakers or mechanisms within it that restrict the committee from making certain decisions. And generally, those specific decisions are around things that really impact the broader owners in general. So, changing owners corporation rules or raising, as you've mentioned, Philip, raising twice the annual budget and things like that, because that's a significant change for lot owners. So there's mechanisms within there. So we don't see many owners corporation groups or groups of owners at AGMs restricting committees to what they can do, because they've elected them in the first place to act on their behalf, and hopefully they make the right elections at that point in time. And then those committee members have a duty to act in good faith and with due diligence and things. So, we see a fairly straightforward position from most lot owner groups in it.
And it can be really unworkable if you've got to constantly go back to lot owners to make a decision on points, because lots of decisions are made throughout the year that lot owners probably don't really appreciate, whether it's, engaging a gardener because the previous gardener's left, or, getting something fixed because it just needs to be fixed. There are a whole lot of decisions that are made on a daily, weekly basis for a lot of OCs.
Okay, thank you. We had a question here that was in chat earlier. We have a complex that has courtyards attached to each lot that are common property. The owner of one lot has recently placed an existing pergola with much more elaborate and costly alternative without seeking any leave to do so. The OC have requested they complete an infrastructure contract and the owner has refused. Can we request the owner remove the structure in lieu of the infrastructure contract being executed? And if they refuse, what are our options?
Yeah, so I mean, I've got a situation as it currently stands where someone's installed like an awning that is external. The reality is the model rules require that if you change the external appearance of a lot, you need to get owner's corporation approval. Further, if you're amending any part of common property, that is, you're changing the structure of it or you're connecting to the structure of common property, then you also you can't alter common property without the owner's corporation's approval. So that approval is required. If it hasn't been obtained, then the question is, should it have been provided or not? And the question really will be is, did the owner's corporation's decision not to approve the work, even retrospectively, is it unreasonable in the circumstances? And there's some cases about what is reasonable and unreasonable withholding of consent to external appearance. But one thing that the VCAT's pretty clear about is, you buy into a development with common property and private lot property as fixed items, and the only way to amend a plan of subdivision is with unanimous consent, putting aside some other kind of applications. So, to some degree, you might be stuck, and VCAT might do a bit. Owner's corporation's got to be reasonable. If there's already, plenty of other similar structures out there that have been approved, then the question is, why isn't this one being approved?
How do owners complain about the behaviour and actions of the committee, in particular breaches of the OC Act? When we brought these matters up, we received written bullying responses from the chairperson. The matter has been handed to a grievance committee, which is made up of members of the OC committee.
That's a tricky one, I think. When you've got the Owners Corporation Committee and the Grievance Committee are effectively similar or the same people. And I mean, you might have a legal view of that, Philip, but there is a mechanism, of course, and it's a bit of a struggle sometimes to do that, but there is a mechanism within the Act that allows owners to call a special general meeting of everyone. You must, of course, obtain 25% of lot owners' support and things like that. So there's a few hoops you need to jump through there. But if you don't believe that the committee that you've elected in the first place are attempting to deal with your dispute or issue correctly, then there is that mechanism. There's not much else that exists beyond that, other than, I guess, a legal path. Philip, you might have some comments on that.
Yeah, I mean, putting aside a committee or a manager that's breaching their statutory duties, and that's can be a really tough thing to prove at VCAT. I think one thing that lot owners, I think, sometimes don't appreciate is that when you buy into a subdivision, you're buying into a subdivision with many other lot owners, and the majority of decisions that are made in Owners Corporation are by simple majority. Now, just like an election we had the other day, 51% need to vote in one way, and then there could be 49% of people that are unhappy about the decision, but the decision still stands, providing it is within the framework of, acting in good faith, acting honestly, in accordance with the obligations of the OC. So you've got to really make a distinction between a lot owner who's complaining about a breach of the statutory duty or a failure to carry out, the Owners Corporation's role, like to repair and maintain common property, as opposed to just not liking the decision. And I think a lot of owners end up at VCAT because they don't like a decision, but don't fully appreciate that they can get outvoted. And really, your only option there is you employ like a PR campaign, whereas rather than fighting everyone, you try and garnish support for your position and get the majority of votes, or you sell up. And I know that sounds harsh, but sometimes it's just, that's the downside of co-owning property with other people, that sometimes you don't get your way. Now, if it's a breach of statutory duty, that's completely different. You go off to VCAT. But if it's just you just don't like the decision, sometimes you just have to just accept it.
Now, I always like to ask presenters if they have any final words they'd like to leave us with before we go. So, Philip, I might jump to you first just to wrap up the session.
Sure. Contrary to my getting income into my own business, the first course with any dispute is to just have a discussion with the other person who you're having a dispute with. If the manager is impartial, use the manager to try and help facilitate it. A lot of the time, from an owner's corporation perspective, a lot of it kind of wants their day in court, but that day in court doesn't actually need to be in court. It can be in a well-held grievance meeting, or just a roundtable at the manager's office or via Zoom, where the person can simply feel like they've been heard. Because at a lot of the time, a lot of disputes, as Joel says, 80% kind of just evaporate because people feel like they're heard, and sometimes that's enough. And sometimes personality conflicts can really exacerbate disputes. And I think committee members need to think twice about whether they take an action on behalf of the owner's corporation, when really it's about spite, not about really the owner's corporation's wishes. And if they do that, they'll stay away from my office, 80% of the time.
Yeah. I think, you've touched on most of those things as well. If you can try and resolve these disputes as best you can first up before getting to any type of formal process, or seeking a lawyer to intervene, I think that's the main focus that you should, and where you should start. And the personality clash is often one that happens. We've got, I've had that in the past, where the dispute has come to our attention and the committee's attention, and it's primarily about a personality clash between those two individuals, more so than something where there's a breach or they haven't complied with the Act or an obligation under the Act or the rules. So focus on the trying to get that resolved sooner rather than later, as easily as possible. Of course, then there's mechanisms within the Act that allow you to escalate that through the formal process. But it's a difficult time out there with disputes and things. So hopefully this helps you a bit in getting through those. But of course, your manager is always there, as Philip has mentioned, and then solicitors such as Philip and others are available as well to support you guys through some difficult things.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.